Everyone taking a break there in that Florida courtroom. Remember, we are still or only at the point of direct examination. We have not seen this cross-examination of Sheila Agee. Let's bring in criminal defense attorney Jeffrey Wolf to talk about what we've seen so far. Jeffrey, she is charged with first-degree murder, being the principal in a conspiracy to commit murder based on what her son did. And it's been an interesting dynamic to see this conversation with her son, because just as much as we saw her say, well, you should go kill her then. Here's the address. I'll be out front. She also says things that are very favorable towards the victim in this case, that she is someone that she has helped and that she believes needs to be around for her child.
Yeah, I mean, what we saw here is the defense putting their best foot forward, right? And a really emotional ending to that direct. So that was well framed by the defense attorney to leave it on that emotional note. And now the jury has the lunch to digest everything that the defense just did there. We can assume that the prosecution has text messages that the defense didn't present there. You know, it's the defense's job to put her in the best light there on direct. Hopefully they've diffused as much of the bad texts as possible on direct, but you got to think that the prosecution has something that they can come with on cross that's going to make her look worse, and that they're going to confront her in a way that will hopefully present her in a less favorable light with the charges that they've brought against her. But, you know, it's a situation where she has had an opportunity to explain why she spoke the way she did to her son and why she was kind of playing along with his plot to try and shake some sense into him. And I think they did a pretty good job on direct.
Yeah. Do you think it's a good decision at this point that she took the stand?
Absolutely, because when you look at those text messages in a vacuum, they look terrible. So they have to be explained. And the only person that can really do a good job of explaining what the motivation could possibly be behind those words is her.
Oh, very true. Let's actually listen back to her son taking the stand during this defense case. He's, of course, convicted of this crime. There's probably an opportunity for him to appeal, but he said this about his mother.
Any time in your life, has your mother ever said anything to you, motivated you, enticed you, wanted you, manipulated you to, or anything else to take Brooklyn Sims' life?
No, sir. I fully believe with 100% that my mother loved Brooklyn. I have my own mind, and once I have something set on my mind, I'm kind of stuck to it. So the only thing that the way that day played out was the only way that day could have played out. She could have not stopped me. No physical words, form, any type of way she could have prevented this. She did the best of her abilities. I feel that she did, as a mother, knowing me, tried to deter me and stop me.
Jeffrey, it's a big deal when you have a co-defendant come in and be able to say that, putting everything out there in a way that may not help them on appeal. But I'm remembering that in those text messages, Sheila Agee told him she wasn't calling the police. And in fact, she did not call the police, despite what he said he was going to do.
Yeah, absolutely. I mean, all of this is looked at, in my opinion, in the prism that this is her son. Okay, so him coming in and falling on the sword, the jury is going to say, well, that's her son. What's he going to do? Come in and say this is mom's fault? But also, when you look at it from the other side, from the prosecution's case of how strong is it that she should have called the police? Well, this is her son, right? So the jury may have some sympathy for a mom there to try and do everything she can to try and talk him out of it, short of calling the police on her own son. Maybe there is a mom on that jury who is going to sit there and put themselves in her shoes, even though the judge is going to discourage them from doing that, to say, would I have called the police on my own son, or would I have tried everything else before I did that? And so this is a unique circumstance. This isn't two friends, and you want to say you can't be involved in this conspiracy. You have to stop and call the police. This is a mother and a son, and it cuts both ways. Of course, he's going to take responsibility and try and save mom, but are you going to call the police on your own son?
And I'm wondering, Jeffrey, if this is a case that's overcharged, if the jury is going to feel uncomfortable with basically treating her as if she pulled the trigger in terms of the charging. I mean, the defense is saying this is a mom who's exasperated with her son. He's angry. But they're also saying that she's trying to call his bluff, but at the same time that she never in a million years thought he would do it. But then why would you need to talk him down if you didn't think that he was going to do something?
It's a common problem in conspiracy cases when the person didn't actually pull the trigger, and a common problem in felony murder cases when the person didn't actually pull the trigger is convincing a jury that the law allows you to charge it this way, but it just doesn't seem fair. When somebody takes the action of walking into a Home Depot, walking up to their girlfriend, the mother of their child, and shooting them in aisle 52 of the Home Depot, and then you have mom who was aware that it may happen and didn't stop it and didn't really talk him into doing it, but didn't stop him from doing it. And suddenly, you know, she didn't help him get away. She didn't aid and abet in him doing the crime. She didn't give him the gun. And suddenly you're going to charge her with the murder too. That's really hard for a jury to shake the hands of their conscience on, that they're going to now convict her of the murder too. The law allows it, but it's really hard for a jury to understand.
We will see what this jury does with this case when we come back. We will take you back to Florida once they get back on the record. So that jury is on the break. Sheila Agee will be back on the stand. Cross-examination will start. You don't want to miss that. We are also standing by in Kentucky where Steve Lawson is set to be sentenced today for conspiring to murder mom of 5, Crystal Rogers, the missing mom murder trial in Tennessee. That hearing is expected to begin at 3 p.m. Eastern. So we'll take you there live when that happens. But we have more Court TV on the other side. Hitting the pause button, let's bring in criminal defense attorney Jeffrey Wolf. And Jeff, let me know what you think about how she's doing on cross. It's getting a bit fiery there.
Well, it's starting fiery is what it's doing. I was always taught about the law of escalating punishment. You wait until the witness gives you a reason to start acting snippy with them and yelling at them. And the reason you do that is because jurors don't like it when you beat up a witness who hasn't given you a reason to do so. And so I would suspect that this jury is not loving the tone of this prosecutor, because it does not come off as fair when you cut off a witness, when you repeatedly interrupt them when they're trying to answer you. This is not a savvy witness who is trying to evade the answer to, or the question with her answers. This is somebody who is trying to answer her questions, and she just keeps cutting her off because she's not getting the answer she wants. And quite frankly, the defense attorney needs to do a better job with his objections of saying that she's badgering the witness, because that's what she's doing. She is badgering this witness. The judge is not protecting the witness in any way, shape, or form. It's a situation where she's trying to answer these questions. She's trying to give her what is a truthful answer to what are set up questions to get a specific response that she wants. And when she's not getting the response she wants, she's angry. And that's just not what you need to do on cross until the witness is giving you permission to do it by being obstructive. And that's just not what I'm saying.
It's interesting analysis, Jeffrey. We really appreciate it. Also interesting that the prosecution is honing in on just the address being provided and that one text about if you don't kill her, you are a blank, blank, blank. We are going to see the next time, Jeffrey. We have to get to our break. We have more of Agee on the stand. She is still testifying under cross. We're also going to keep you posted after that is done with this sentencing happening in Kentucky for Stephen Lawson in the Crystal Rogers murder case.